May it please the Court, my name is Andrea Cruz and I represent PepsiCo, the defendant in this case. PepsiCo is hereby requesting that the Court consider this motion for relief and set aside the default judgment of $1.26 billion because of a qualifying reason under Federal Rules of Civil Procedure 60 and because PepsiCo is able to show good cause for vacating the judgment. Although a PepsiCo secretary accepted service in this suit, she set the documents aside because she was in the middle of preparing for an important board meeting. But only when she received a copy of the plaintiff's default judgment motion several weeks later did she remember the earlier documents. By that point, the court had already entered a default judgment. Federal Rules of Civil Procedure 55C provides that a court may set aside an entry of default for good cause, and it may set aside a final default judgment under Rule 60B. The Secretary's failure to forward the documents is excusable neglect under Rule 60B1. So the court will then consider three factors to determine whether there is good cause to set aside the default judgment. First, the court will consider whether the relief-seeking party engaged in culpable conduct by intending to prevent judicial proceedings or by recklessly disregarding the effect of its conduct on those proceedings. But failure to answer a complaint for which a defendant has a credible good faith explanation does not qualify as intentional. PepsiCo didn't even realize it had been served with a summons and complaint because of the excusable neglect of the secretary, which is different than the 1999 case of Rogers v. Hartford Life Insurance Company, in which the Fifth Circuit Court decided a claim examiner's conduct was not excusable neglect. There, the examiner knew the company had been served, was expecting to receive the summons and complaint from the registered agent, but did not follow up when she never received the documents. Here, the PepsiCo secretary who accepted the summons and complaint did not notify anyone about the documents, but merely set them aside to handle later and then simply forgot about them. Accordingly, PepsiCo may have been neglectful, but it did not intentionally fail to answer. Because neglectful conduct does not qualify as culpable, this factor weighs in favor of the court vacating the default judgment. Next, the court will determine whether the plaintiffs will be significantly prejudiced by setting aside the default judgment. Here, a $1.26 billion default judgment is based on an unintentional procedural mistake. Because the plaintiffs waited 13 years after PepsiCo formed Aquafina to file suit, and this case has barely gotten started, the plaintiffs will not be harmed if this court vacates the default judgment. But allowing this judgment to stand would unjustly provide the plaintiffs with an unprecedented windfall on unsubstantiated claims, and the court has adopted a policy in favor of resolving cases on their merits and against the use of default judgments. So based on there being no prejudice to the plaintiffs and strong policy reasons to judge the case on its merits, this factor weighs in favor of setting aside the default judgment. And finally, this court will determine if the defendant has a meritorious defense, which PepsiCo does. Because the law requires very specific details when it comes to misappropriated trade secrets, there's a strong possibility that the outcome of this suit after a full trial will be different than the results of the default. The plaintiff's only claim is that they had an idea about a new soft drink back in 1981, and recently after reading an Aquafina label did they discover that PepsiCo had supposedly used their confidential idea. But PepsiCo has been marketing Aquafina since 1996, and a claim of this nature had to be filed within 3 years of when the plaintiffs knew or should have known that their idea had been stolen. Therefore, the underlying complaint is defective. And based on PepsiCo's meritorious defenses, this factor weighs in favor of setting aside the default judgment. So in conclusion, because of all three of the above factors supporting vacating the default judgment, PepsiCo respectfully requests that this court grant its motion for relief.